Okay, this is Remax Real Estate Professionals, Inc. and Tim Sabrowski versus B&H Green Enterprises LLC et al., docket number 20-588CB. This is the time set for hearing on the defendant's motion for summary disposition under MCR 2.116C8. And I'll take appearances first for the record.
Good afternoon, Your Honor. Peter Brown on behalf of the plaintiffs.
Good afternoon, Your Honor. Michael Matheson on behalf of the remaining defendant, B&H Green and New Life Assisted Living Centers.
All right, thank you. Mr. Matheson, this is your motion. You may go ahead.
Thank you, Your Honor. This is the very type of case that the legislature intended to bar pursuant to the statute of fraud. I'm getting some feedback there. Can you hear me okay?
Yeah, I'm not getting it.
Okay.
It must be wait a minute. Are you getting it?
Well, when somebody was just talking, when he started getting feedback, I could hear something in the background.
You don't have two devices that are picking you up, do you?
No.
Okay, I'm not getting it.
Okay.
The court recorder says
Let me see how that sounds.
she doesn't think she's getting it, so go ahead.
Okay. Again, this is the very type of case that the Michigan legislature intended to bar under the statute of frauds, particularly as it relates to a recent amendment to the statute of frauds. Initially, as it has stood for a long period of time, MCL 566.132(1)E of the statute of frauds provides an agreement, promise, or contract to pay a commission for or on the sale of an interest in real estate must be in writing to be enforceable. In May of 2020 of this year, the Michigan, I guess that would be last year, now that we're into 2021, added an additional provision to the statute of frauds that I would contend heightens the bar on any claim of a commission as it relates to the sale of real estate. And that's what we have here. The Michigan legislature specifically provides that in the absence of a written agreement, the party claiming a commission is forbidden from pursuing a commission claim unless that agreement is in writing. Now, there's no other aspects of the statute of frauds that receive the same treatment. As I briefed, this arises out of a case involving a claim for a broker commission that actually survived on claims of promissory estoppel and other implied in law contract claims. And now the Michigan legislature has expressly said those types of claims are excluded by way of the statute of frauds in the absence of a written commission agreement. So it's not only just the fact that 1E provides for commission agreements to be in writing, but subsection 3 further provides that such claims are barred unless they are in writing, and a plaintiff can't proceed forward with litigation. And that's specific to claims for real estate commissions. So as Your Honor made note, the motion was originally filed under MCR 2.116C8. And my original effort was to contain it to the pleadings as I understood Michigan law and its preclusion under the statute of frauds from any sort of extrinsic evidence and other claims of verbal agreements upon which the initial motion was based under 2.116C8. Now I recognize there obviously 2.116C7 as cited by Mr. Brown expands upon what can be permitted. And I think we're into the area beyond a C8 at this point, although I would contend that a motion could be awarded under C8 contained to just the pleadings, because what we come down here to is simply whether or not that January 19th email constitutes a writing sufficient to satisfy the statute of frauds. I'm not going to get into the other counts. I think it's pretty clear that those are barred by the amendment to the statute of frauds on the unjust enrichment, promissory estoppel, and I think there was one other one that was filed. I think those are clearly barred. What we come down to here is the contract claim and whether or not the email from Mr. Green to Mr. Sabrowski satisfies the writing requirement under the statute of frauds. Obviously, our position is that it is not a sufficient writing. There's many defects associated with that email and clearly does not rise to the level of a writing that's contemplated under the statute and Michigan law. Specifically as it relates to the any commission part of it. I cited and attached the affidavit of Mr. Green, where we get into this whole notion of who was Mr. Sabrowski even acting as an agent for. Mr. Green was always under the impression that, and as was told to him by Mr. Sabrowski, that he was acting on behalf of the buyer and had a written agency agreement with the buyer. Well, come to find out when the transaction gets to the stage of being documented, we've got this back and forth over who Mr. Sabrowski is even representing. And plainly, Mr. Green does not acknowledge any agency with Mr. Sabrowski. There's no written agency agreement. And unbeknownst to us, he also didn't have an agency agreement with the buyers either. And that should be undisputed, that there is absolutely no written agency agreement with either the buyer or the seller. And I did make the argument because I think there was a play on some equities and some other aspects of, well, he put in all of this work and all of this effort. Well, we don't deny that he was part of the transaction, but what Mr. Sabrowski represented to my client, and it's reflected in the documentation, that he's the buyer's agent, and that was false. It's not true. And it's attempted to be shown in that fashion as late as, I know, February of 2020, when Mr. Sabrowski apparently realizes that he doesn't have a written commission agreement and then presents a broker fee commission agreement to my client in an effort to get him to sign a broker commission agreement. This is in February, after that LOI was already signed and the parties have exchanged the offers on the sale of the property and businesses. So if he really believed that there was a written fee agreement in place, why is he attempting to have my client execute this broker agreement after the fact? So to me, that's quite telling that the statements in that email do not commit my client to payment of a commission. It says any commission. It doesn't represent or state that my client agrees to pay a commission. Now, Mr. Sabrowski claims there were some other conversations, but that was flat rejected by my client. So it just doesn't make sense that there was some sort of commission agreement made. And then we've got this email saying any commission is going to be at 2% because my lawyer has to do all of this drafting. And so if there was indeed already a 2% commission agreement, the entire context of that email doesn't make sense, not only from any commission standpoint and not committing either the buyer or seller to paying a commission, but there wouldn't have been a need for Mr. Green to explain why, in his opinion, because he was operating under the assumption Mr. Sabrowski had a 3% deal with the buyers, that he was trying to negotiate a lower commission because the parties were several hundreds of thousands of dollars apart in consummating a transaction, and the payment of commissions is a big factor in that. So when you review the testimony of Mr. Green in light of the email, my position is that the email in and of itself is insufficient to satisfy the statute of frauds. but certainly with the context and an additional explanation by Mr. Green, that further supports the argument that this is just simply not an adequate writing to satisfy the statute of frauds. And then coupled with the fact that he was acting as nobody's agent, had no signed written agreement. And in February, he tried to get my client to sign a written fee agreement. So all of these things point to the fact that that email is an insufficient writing under the statute of frauds. So with that, I will pass things over to Mr. Brown and reserve a few minutes for any sort of rebuttal. Thank you, Your Honor.
Sure. Mr. Brown?
Good afternoon, Your Honor. I'd start by just briefly discussing the grounds for the motion for summary disposition. This was originally filed as a C8 motion. Your Honor, as the court knows, C8 motions test the legal sufficiency of a claim. They're decided on the pleadings alone. Here, with respect to the breach of contract claim, we allege in the complaint that there was a valid and enforceable agreement that the sellers were to pay this 2% commission to the plaintiffs, that the plaintiffs performed under that agreement, and that the sellers breached by their failure to pay the 2% commission, and that the plaintiffs have been damaged. So pursuant to a C8 motion, Your Honor, this motion should be denied. Although it was formed as a C8 motion, the defendant's motion really asserts two alleged defenses. First, the defendants assert that the statute of frauds it bars this claim. That's more appropriately asserted under a C7 motion. And similarly, the defendants claim that there was a lack of mutual assent or a lack of the meeting of the minds, which is a factual issue that I would think would be more appropriate under a C10 motion. So I will be discussing, I guess, both of those grounds in the motion or in our response. With respect to the statute of frauds, Your Honor, or a C7 motion, the claims by the plaintiffs are not barred by the statute of frauds for two reasons. First, the January 19th, 2020 email satisfies the statute of frauds. The email is definitely in writing. It provides for an agreement that the commission for the sale will be at 2%, and it's signed by the party to be charged by the agreement, albeit electronically, but it's signed. Second, even if the email does not satisfy the statute of frauds for some reason, the seller's agreement to pay the commission to the plaintiff should be removed from the operation of the statute of frauds based on the doctrine of part performance. There's no doubt about it that the plaintiffs, Mr. Sabrowski, relied upon the seller's repeated commitments to pay the commission to the plaintiffs. There were repeated statements and representations that the sellers would be paying this 2% commission, and the plaintiffs substantially performed on that pursuant to that agreement, to the extent that it would be a fraud on the plaintiffs to allow the sellers to repudiate the agreement by interposing the statute of fraud. So for those reasons, the plaintiff's claims are not barred by the statute of frauds. With respect to the defendant's claim that there was no meeting of minds or mutual assent, the plaintiffs submit that it's really a factual issue, maybe more appropriate for a C10 motion, but we would still submit that there is actually no genuine issue of material fact, that there was a meeting of the minds, and that regardless of the oral conversations, that can be determined just from the January 19th email. And so we would submit, Your Honor, that the plaintiffs are entitled to summary disposition pursuant to 2.116I2. I think a summary, I don't want to spend a lot of time on the facts here. I spent a lot of time in our brief summarizing the factual background. But I did that because I think the facts in this case are very important. In the real estate industry, there are, of course, certain times where a broker has a quick listing or a quick sale, and they don't expend much time, effort, or resources, and they earn a commission. This is not one of those cases. And so that's why I think it's important to talk about a little bit of the background here. The buyers came to Mr. Sabrowski. Mr. Sabrowski sought out the Greens. He introduced the parties to each other. He connected them. This is an opportunity that was procured by Mr. Sabrowski. Mr. Sabrowski was the procuring cause of this transaction, but for him, this transaction likely does not occur. The plaintiffs expended substantial time, effort, and resources to pull this deal together and coordinate the sale over a course of several months. It started with the financing. Mr. Sobrowski was involved with both Dart Bank and Huntington Bank, assisting the buyers with the financing. He was involved with the due diligence process. There were situations where the buyers were seeking certain documents from the Greens. He would go to the Greens. Everybody executed a non-disclosure agreement on RE/MAX letterhead. Mr. Sobrowski would go to the Greens, obtain these financial documents from their CPA. He had access to all of Mr. Green's financial documents, and then he would provide those to the buyers. And then similarly, he was instrumental in facilitating the negotiations regarding the purchase price. The buyers would submit an offer to Mr. Sobrowski. He would go to Mr. Green. Mr. Green would then provide a response and direct him to go back to the buyers. And he was instrumental in negotiating the purchase price that ultimately resulted in the letter of intent being executed on January 22nd. So, in the plaintiffs' work, Mr. Sobrowski and the plaintiffs weren't doing this just out of the kindness of their own heart. He was doing that because he had a real and reasonable expectation to be compensated for those services. And that expectation wasn't just as a result of Mr. Sobrowski's imagination. It was a result of repeated representations by Mr. Green that the sellers would pay Mr. Sobrowski and the plaintiffs this 2% commission. It was interesting in the reply that Mr. Green's affidavit said that at no time during our meetings or conversations did we discuss commissions to be paid by the Greens. And that is surprising. There were at least 3 different occasions when Howard Green specifically told Mr. Sobrowski that he would pay the 2% commission on the full purchase price. There was three conversations where they discussed commission, at least 2 conversations where he said that the 2% commission will be paid by the sellers. And then there's the one email which memorializes that agreement. And so those 3 conversations were first during the first conversation when Mr. Green replied to the initial phone call after the buyers had contacted Mr. Sobrowski. Mr. Sobrowski reached out to Mr. Green during that initial phone conversation. Because this was not a listed property, Mr. Sobrowski inquired of Mr. Green and said, "Will you be willing to pay a commission on this?" And Mr. Green confirmed that. Subsequently, I believe it was late December or early January, after the buyers had given an offer to Mr. Green, Mr. Sobrowski and Mr. Green met at the Harrison Roadhouse. There was a conversation at that time where, again, the issue of the commission was brought up, and they specifically talked about the 2% commission at that meeting. It was then after that, on January 19th, where the email was sent from the Greens to Mr. Sobrowski stating that any commission for the sale will be at 2% because their attorney will have to be drafting some documents. And Mr. Green was clearly the Greens were attempting to limit the amount of commission that the Greens would have to pay. Lastly, at the signing of the letter of intent, there's this meeting where everybody is there. Mr. Sobrowski's there, the sellers are there, the buyers are all there. The letter of intent gets done. The deal is done. Everybody's hugging, handshaking, crying. Again, there is an additional conversation there where the Greens confirmed that the sellers would be paying the 2% commission. So from the first conversation till the signing of the letter of intent, there was repeated representation that sellers were going to be paying this 2% commission, and that is reflected in that January 19th email. Things started to fall apart, at least from Mr. Sobrowski's standpoint. Once he has that letter of intent done, both parties now have attorneys, and the purchase agreement begins to be drafted. And the buyer's attorney attempted to shift the commission over to, the seller's attorney attempted to shift the commission over to the buyers, and also attempted to shift half of the transfer tax over to the buyers. And so at that point, obviously the buyer's attorney objects, and they're attempting to take advantage of the fact that there is no written agency agreement, although there is definitely an agreement to pay the commission. And so when I say there's no agency agreement, we acknowledge there is no express exclusive listing agreement. There's no express signed buyer's agency agreement. But nevertheless, so at this point, he's being written out of the purchase agreement. So at that point, Mr. Sobrowski on February 22nd attempts to send the commission broker fee agreement to the Greens to try to get them to sign that, because at that point, he had already seen the draft purchase agreements that was drafted by the seller's attorney attempting to write him out of the purchase agreement. At that point on March 5th, the buyer's attorney basically says, you don't have an agency agreement, you're not entitled to a commission, and that's where this whole situation occurs. I'd like to talk about the agency relationship for a moment. The defendants make a big deal about who Mr. Sobrowski represented or who the agency. I would caution the court not to get distracted by that issue. It's a red herring. The plaintiff's agency relationship with the parties is certainly not dispositive as to this issue. And I don't even think it's relevant to the issue in this case, which is whether there's an enforceable agreement wherein the sellers are obligated to pay the commission to the plaintiffs. In other words, Mr. Sobrowski could have been representing the buyers, he could have been representing the sellers, he could have been a dual agent, or he could have been representing neither one of them. But I think when you look at the common law principle of agency principal relationship, there was certainly, although there's no express agency agreement, there was certainly for months, there was implied and apparent authority to act on behalf of both of the parties. And both of the parties knew it. Both of the parties were using his services. This was a commercial transaction, a commercial property, so there was no duty to somehow disclose the agency relationship. Mr. Sobrowski trusted the sellers that he was going to get paid on this commission. They thought that he was going to be written into the purchase agreement. He was acting at the direction and as an agent for both parties. Both parties were using Mr. Sobrowski's and the plaintiff's services, resources. He was acting at their direction both ways with respect to due diligence and negotiation of the purchase price. So with respect to the arguments, Your Honor, the statute of frauds, as I mentioned, the January 19th, 2020 email certainly satisfied the statute of frauds. This email was in writing. It is certainly signed by the parties to which it's charged. It's signed by Howard and Brenda Green. That's detailed in my brief. With respect to that, is sufficient to be a signature on the writing. And the writing definitely says that any commission for the sale will be at 2%, seeing that our attorney will have to review the documents and will be handling our side of the closing. So it does contain the essential terms. The commission will be at 2%. And it is clearly an attempt by the sellers to limit the amount of commission that they will have to pay for this sale transaction. Your Honor, even if this email doesn't satisfy the statute of frauds, which we submit that it does, but even if it doesn't, this is clearly a case where the doctrine of part performance would come into play. There were, at a minimum, 3 different oral conversations wherein we would submit, and it's been attested to in sworn statements, that the sellers represented that they would be paying the commission to the plaintiffs. We submit that that's memorialized in this email. As you know, a party's performance, in order to be applicable with the doctrine of part performance, the party's performance must be substantial and important, and the act constituting partial performance must be prejudicial to the performing party. Here, there's no question that Mr. Sobrowski's actions were substantial. There's no question that it was detrimental and prejudicial to the plaintiffs, and there's no doubt about it that the defendants received a substantial benefit from it. In the reply, the defense mentions that the doctrine of part performance only applies to transfers of land. That is absolutely not true. The authority for that is Giordano versus Markovitz. That's Giordanov MARKOVITZ, that's 209 Mich App 676. It's a 1995 case. Certainly, it is applicable to other transactions, including for the commission on the sale of real estate. So, Your Honor, this court of equity can and should take this transaction out of the statute of frauds and grant specific performance of the seller's agreement to pay the 2% commission of the purchase price to the plaintiffs. Lastly, with respect to whether there was a meeting of the minds, Your Honor, as you know, an ambiguous contract is a question of fact. An unambiguous contract is a matter of law. A contract is ambiguous when its provisions are capable of conflicting interpretations. But if the contract, although inartfully worded or clumsily arranged, fairly admits but one interpretation, it's not ambiguous, we would submit to the court that you could look at just the four corners of this email without worrying about any of the other oral representations that were made. You could look at the four corners of this email and only come to one conclusion. The defense raises three issues with respect to this email, the contents of the email, to suggest that there was no meeting of the minds. One, they question to whom the commission was to be paid. There's no doubt about it. Mr. Sabrowski and the plaintiffs were the only broker or agent involved in this transaction. They acted substantially. There's no doubt about it that the commission was to be paid to the plaintiffs. The defense raises the issue of by whom the commission is to be paid. When reviewing this email in context, there's no question about who is going to be paying this. It's qualified. There's qualifying language in here that says any commission for the sale will be at 2%, and doesn't end there. It says, seeing that our attorney will have to review all documents and will be handling our side of the closing. They're saying that they're going to be incurring other professional fees because they have an attorney who's going to be drafting the documents, and they're attempting to limit the 2% commission or the obligation that the sellers will have to pay to the plaintiffs. I think in the reply brief, there was some mention that the sellers were attempting to limit the 2% in hopes that it would reduce what the buyers would have to pay in hopes of closing the gap. That's not at all what that's not a reasonable interpretation of this sentence. If that was it, it would say, any commission for the sale will be at 2% because maybe that'll help get the deal done. That's not what it says. It says any commission will be at 2%, seeing that our attorney will have to review the documents. There's some context there that I think that is very, very important. And lastly, the defense argues that there's a question as to on what property this commission is to apply. I think that is very clear also from the four corners of the documents. They talk about Brenda and I are firm at 5.5 million. We will negotiate a little bit, but not very much. Also, any commission on the sale will be at 2%. There is no limiting language there to suggest that it was only for the real estate or only for the personal property. There's no question that this is for the entire sale of the transaction. And so we would submit that not only should the defense motion be denied, but Your Honor, when reviewing this contract or this email under the four corners of the email and the terms that are contained in that email, there can be only one interpretation. As a result, that is not an unambiguous contract. It's actually a memorialization of the agreement that the sellers had represented to the plaintiffs and that the plaintiffs substantially relied on. And as a result of it being an unambiguous contract, Your Honor, as a matter of law, we would submit that the court can and should grant summary disposition in favor of the plaintiffs. And I'd be happy to answer any questions that you may have.
I don't have any. I'll turn to Mr. Matheson. He wanted rebuttal. You're muted. Common saying these days, you're muted.
I was trying to make sure there wasn't any feedback, as all too happens when you're not muting yourself. But thank you for the heads up, so I didn't spend my couple of minutes speaking to myself. Mr. Brown makes a very eloquent argument for why this court should consider those facts under a claim for promissory estoppel and unjust enrichment. That's not what is before this court. As I argued and presented in the briefing, the Michigan legislature plainly extinguished any type of unjust enrichment or these implied in law contracts. That's what Mr. Brown spent 20 to 30 minutes arguing about. And I would contend that if this was only a breach of contract complaint, a lot of those factual claims in context over, we had the discussion while we were sitting at lunch at the Roadhouse and had these other verbal agreements. I mean, that wouldn't be even brought up in this context, because what they're trying to do is resurrect or rehabilitate the fact that there is no written commission agreement that even says who's going to pay the commission. It doesn't say anything in there about either the buyer or the seller paying the commission. That's a fatal flaw in the argument that this is sufficient in writing. Whether it's a lack of mutuality of obligation, mutual assent, and there's just simply not enough here to provide that there was a clear agreement for 2% for the sellers to pay 2% on the sale, and that's evident by the subsequent efforts of Mr. Sabrowski to get the signed written agreement that he really didn't have. And I would lastly just kind of summarize this. Mr. Brown made the argument that Mr. Sabrowski had a real and reasonable expectation of getting paid a commission. I have a question: from whom? I mean, certainly there's no written agreement from the seller to pay a commission, and there's no indication that they had any sort of agency or written fee agreement from the buyer. So, I mean, this is the exact type of situation that is sought to be avoided under both sections of the statute of frauds, and would request that summary disposition be awarded in favor of the defendants. Thank you.
All right, thank you. Well, first of all, it's best to start with what there's no dispute over. There's no dispute that any agreement for the payment of a commission for the sale of real estate has to be in writing. The defendants in their brief, I mean, this seems to have gone back and forth between both sides. They say the plaintiff is relying on oral agreements. And although there's been a lot of discussion in the briefing and today about oral communications, the plaintiff very clearly is not relying on oral agreements. The complaint alleges that there's a valid enforceable written contract, and it alleges that that valid enforceable written contract is the email, the January 19, 2020 email. And in the response to this motion, the plaintiff again says the January 19 email alone is the written agreement and is sufficient. So even though both sides are talking about a lot of oral communication, this is a motion that was clearly brought under the statute of frauds, and it is clearly the email that the plaintiff is relying on as the written agreement. So, you know, the question is that sufficient? I mean, is that a written agreement that meets the requirements? And there is only that one writing with respect to the commission, and it's the January 19 email. That email standing alone either is or is not sufficient to satisfy the statute of frauds. The email is from the Greens to Mr. Sabrowski, and it says, "Hi, Tim. We'd like to start by saying thank you for the offer. Brenda and I are firm at 5.5 million. We will negotiate a little, but not much. Also, any commission for this sale will be at 2%, seeing that our attorney will have to review all documents and will be handling our side of the close. Please get this done. Thanks, Howard and Brenda Green." The email is a writing, and it is electronically signed by the Greens, who are the sellers, authorized representatives of the sellers, and the party to be charged. The defendants say that the email standing on its own doesn't show mutual assent. The defendants say, first, the January 19th email referring to any commission is nothing more than an indefinite expression and part of Howard Green's overall understanding that Tim Sabrowski was the buyer's agent and was receiving a commission from the buyer. Further, the defendants say The January 19th email was a non-committal encouraging attempt to have Tim Sabrowski agree to a lower commission from his client, i.e. the buyer, so the parties could reach agreeable terms to the purchase. I just cannot agree with any argument that the email was referring to a commission to be paid by the buyer or an encouragement to get Mr. Sabrowski to agree to a lower commission from the buyer. First, the email definitively states, quote, any commission for this sale will be at 2%, end quote. It doesn't say, my understanding is that your commission has been set at 2%. It doesn't say, will you take 2%? Second, it's not referring to the buyer because the sentence goes on to say, seeing that our attorney will have to review all documents and will be handling our side of the close. There simply is no other reasonable reading of the email other than the Greens agreeing to pay a 2% commission on the sale. The defendants say that everyone knows that a written commission fee agreement must be signed, and I am sure that there is a document entitled Commission Fee Agreement that is customarily signed. But legally, to satisfy the statute of frauds, all that's required is a writing sufficient to satisfy the statute of frauds. Something in writing that states the terms and is signed by the party to be charged. And the January 19th email does that. The defendants also say that the email is insufficient to show a meeting of the minds regarding a commission. They say because there's no agreement as to whom it's being paid, by whom it's being paid, or on what property it's being calculated. And again, we need only examine the email itself to assess that, because that is the only writing that could satisfy the statute of frauds, and that does satisfy the statute of frauds. However, contrary to what the defendants say, the email unambiguously provides that the plaintiffs would be paid a commission. It's sent to Tim Sabrowski. The commission will be 2%. It also unambiguously provides that the sellers would pay it for the reasons that I've already given, and that it would be calculated based on the sale price, because it says any commission for this sale will be at 2%. So I do have to disagree as well that the email does not show a meeting of the minds as to the essential terms that a writing is supposed to show a meeting of the minds on, because it meets all of those requirements. Now, I have to go back a little bit and discuss this whole thing about the other evidence, the affidavits, the other conversations. It was all very, very difficult to sort out because frankly, it's hard for me to reconcile the statute of frauds. And this really is, even though it's brought under C8, it's a C7 motion. I guess we could call it C7 and C8 because C7 specifically provides statute of frauds. And to me, typically you would analyze a statute of frauds argument just this way. Is there a writing? If there isn't, you lose. And if there is it the writing on its face sufficient to satisfy the statute of frauds, and does it provide a meeting of the minds? The four corners of the written agreement would be sufficient. So you wouldn't look outside of that for a statute of frauds argument. However, C7 says you can submit affidavits. So it was very, very difficult to grapple with that in order to assess how you could have a factual dispute and affidavits and a factual dispute that would preclude summary disposition in a case such as this. And I'm still not sure how, but out of an abundance of caution, I'm going to address Mr. Green's affidavit as to whether it could create a factual dispute. Now, I've already indicated that the email is unambiguous and is only subject to one reasonable interpretation. So I've analyzed Mr. Green's affidavit, and first of all, he basically says that in his affidavit that he meant something other than what the email says. And, you know, if the email, if there was room for some ambiguity or different interpretation of the email, that would be one thing. But I've already found that there isn't. So Mr. Green saying in his affidavit that he meant something different really can't change the unambiguous nature of the email. Furthermore, Mr. Green says that if he was agreeing to a 2% commission, then the email would have said 2% will be paid by seller. But actually, I see no appreciable difference between that statement and the email itself, which says any commission for this sale will be at 2%, signed Howard and Brenda Green. And then Mr. Green says in his affidavit that Mr. Sabrowski never wrote back and confirmed that the commission would be 2%. The statute of frauds requires that the writing be signed by the party to be charged, in the Greens in this case, and the Greens signed the email. True, there is no email from Mr. Sabrowski that directly responds to the 2% commission, but in response to the Greens' agreement to 2% and their direction to, quote, get this done, end quote, which they made at 3:28 p.m. on January 19th, Mr. Sabrowski provided a letter of intent dated the very next day, January 20th. So I don't think his failure to directly respond to that email when he's not the party to be charged signed it and sent it. I don't think his failure to respond directly to that email changes any of the analysis. And then Mr. Green says that if Mr. Sabrowski believed he had a written agreement, then why would he have produced on February 25th a written commission broker fee agreement? But to that I say that does not create an issue of fact. And in fact, it cuts more favorably the other way. Mr. Sabrowski submitted a more formal agreement that reflected exactly what was agreed to in an unambiguous email agreement. So I have to reject that as well as creating any kind of an issue of fact. And then finally, Mr. Green says that if Mr. Sabrowski was entitled to a 2% commission, then he should have included it in the letter of intent. But I just don't think that creates any issue of fact with respect to the statute of frauds or meeting of the minds of the parties. The letter of intent signed by the buyers and sellers is simply silent as to any commission. The day prior, the Greens said to Mr. Sabrowski that the commission would be 2%, seeing that their attorney would have to review documents and handle the closing. And the next day, Mr. Sabrowski, through his efforts, produced a signed letter of intent, albeit one that didn't address the commission. But again, I don't think its silence on the commission creates any kind of issue of fact, given that there was an unambiguous agreement the day prior. So for all of those reasons, I am denying the defendant's motion for summary disposition under C7, C8, and I am granting the plaintiff's request for judgment in the plaintiff's favor under I2. And Mr. Brown, do you want to prepare an order that indicates that?
I will prepare an order, Your Honor. Thank you very much.
All right, thank you.
Thank you.
And